on a cold February morning in 2017, law enforcement didn't just enter a house in Oakland Township, Michigan. They stepped into a collision between authority and accountability. Oakland County deputies executed a search warrant at the home of Joseph Shealy, a tenured business professor at Oakland University. On paper, Shealy represented stability, academic tenure, professional respect, institutional trust. But anonymous tips told a very different story, one involving student parties, drug use, and boundaries that had quietly collapsed. Inside the home, deputies found 4 young adults. One of them was Jacob Spencer. What officers recovered would soon reshape the narrative: ketamine, 2 rifles, and a shotgun. All of the firearms were unloaded, but their presence mattered. In the legal system, proximity and context often carry as much weight as intent. Just 2 days later, on February 17, 2017, prosecutors filed 7 criminal charges against Shealy. The list was extensive: possession of ketamine, maintaining a drug house, multiple counts of possessing firearms during the commission of a felony, and 2 counts of delivering ketamine. One of those delivery charges centered directly on allegations involving Spencer. By January 2018, the case reached trial in Oakland County Circuit Court, with Judge Cheryl Matthews presiding. This is where the case shifted from police reports to human testimony, and where the legal strategy became impossible to ignore. Jacob Spencer took the stand for the prosecution, but not as an ordinary witness. He was granted use immunity, a legal safeguard that allows a witness to testify about potentially incriminating behavior without that testimony being used against them in their own criminal case. It's a tool designed to extract truth, but it comes with a cost. Use immunity doesn't erase wrongdoing. It simply redirects accountability. It asks the jury to weigh testimony given under protection, knowing that the speaker is shielded from consequences tied to their own admissions. After the prosecution finished its direct examination, Shealy's defense attorney, Neil Rocky, began cross-examination. This is where the trial's tension crystallized, because cross-examination isn't about storytelling. It's about pressure. It tests memory, motive, and credibility. And at the center of it all sat a single, uncomfortable question: how much responsibility belongs to the person with institutional power, and how much to the young adults operating within that orbit? This case wasn't just about drugs or firearms. It was about what happens when authority creates an environment where lines blur, and when the legal system must decide where protection ends and accountability begins.
Mr. Spencer, you have been around people who have used narcotics, haven't you?
Yes.
And you've seen people who, in your experience, appear to be high, haven't you?
Yes.
Who appear to be under the influence of some kind of a drug or affected by some kind of a narcotic, haven't you?
Yes.
Can you look the jury in the eye and tell me whether or not you've taken any narcotics today? Prescription pills, anything of that sort? Xanax, opiates?
Yes, I have taken prescription pills today.
When did you last take a prescription pill today?
This morning.
What time?
I'd say around 9 o'clock.
And what medication did you take this morning around 9 o'clock before you came to court?
I took Vyvanse.
Vyvanse. Vyvanse is an amphetamine?
Yes, I'm prescribed.
Vyvanse is for ADHD?
Yes.
The behavior, the way that you're communicating, and I'm going to speak to you, try to speak softly and have a dialogue with you, okay?
Okay.
The way that you're communicating now, isn't this the way that you've seen people communicate in your own personal life who appear to be high or under the influence?
Judge, I'm going to object to that.
What's that?
Judge, he can ask him if he's high or under the influence, but
I'm not to ask him.
he's asking him to evaluate his...
I don't understand the question.
Okay.
I don't understand how I could look at myself from a third-person view.
So well, first of all, so the prosecutor objected, Your Honor.
Say the question again, I didn't understand.
Yeah, sure. The way that you're communicating now, I mean, can you hear, I'll withdraw and I'll ask it differently. Can you?
Are you high right now?
No, I'm not.
Okay.
This is the way that you normally communicate?
I don't normally communicate from a stand in circuit court in a case involving an older man that threw parties with underage people providing drugs. I'm nervous. If you're accusing me of being drugs, then you're doing a very bad job as an attorney. Okay. You should be asking questions that are actually going to help your client.
Okay, next question.
I appreciate that.
And now I'm angry, and I'm going to tremble my voice even more, not because I'm on drugs, but because I'm nervous. And you're intimidating. That's what you do.
Okay, wait,
It's not going to work.
Okay, just answer the questions and then.
That's my answer.
Okay, just answer his questions and we'll get you out of here, okay? All right, go ahead,
Okay.
Mr. Rocco.
Thank you, Your Honor. Today, you testified a few moments ago to the jury in response to Ms. Hand's questions that Joe has provided you with ketamine on prior occasions at his house.
Correct.
And you said it was almost, I think I wrote down, said almost every time you were there. You remember that?
Yes.
At the preliminary examination, that was when you testified before in district court. Do you remember that?
Yes.
And you took an oath at that time, is that right?
Yes.
And at the time that was closer in time to the events of February 15th, true?
Yes.
And you told that time you were asked this question, and this was your answer on page 62. Approximately how many times had you ingested ketamine that the defendant gave you at his house? Your answer, it was one time. It was that night. Wasn't that your answer under oath at the preliminary examination?
Yes, it was.
Today you've told the jury something different, haven't you?
Yes, I have.
So, 2 times under oath, you've given 2 different answers. True?
True.
Both of those pieces of testimony can't be true, right?
This is the moment where the trial stops being about evidence and starts being about belief, because facts alone don't convict, people do. During cross-examination, defense attorney Neil Rockhind didn't introduce new evidence. He did something far more dangerous to the prosecution. He attacked credibility. Jacob Spencer had already told 2 different versions of the same story. On the stand at trial, he testified that he received ketamine multiple times. But earlier, under oath during his preliminary examination, he swore it happened only once. That gap matters. In criminal court, inconsistency isn't a small flaw. It's a crack in the foundation. This tactic is called impeachment, and despite how dramatic the word sounds, it isn't about insults or aggression. It's about memory versus motive. Under Michigan Rule of Evidence 81-D1001A, prior sworn statements don't get dismissed as hearsay if 2 strict conditions are met. First, the witness must be testifying in the current proceeding and be available for cross-examination. Second, the earlier statement must directly conflict with the testimony being given now and must have been made under penalty of perjury. Jacob Spencer met both conditions, which means his past words weren't history. They were weapons. Rockhind was legally allowed to place Spencer's own sworn testimony in front of him and ask the question juries are trained to fear which version is true. This is where use immunity becomes uncomfortable. Spencer could speak freely, protected from prosecution based on his testimony, but protection doesn't guarantee trust. In fact, it can invite skepticism. When a witness knows they won't be charged, every inconsistency becomes louder. Was the story changing because memory faded, or because the narrative needed to grow stronger? That's the doubt impeachment is designed to plant, and it works quietly. There's no objection that fixes it, no redirect that fully erases it. Once a jury sees a witness contradict themselves under oath, they don't forget it. This wasn't about whether ketamine existed, or whether it was illegal. It was about whether the prosecution's key witness was reliable enough to carry the weight of 7 criminal charges. Cross-examination doesn't prove innocence, it creates hesitation. And in a courtroom, hesitation is power. Because when a case leans heavily on testimony, and that testimony bends under pressure, the law doesn't ask jurors to guess. It asks them to doubt. And sometimes that's all the defense needs.
I know you said to only keep this yes and no, but I'd like to explain that this isn't about the amount of times that I did ketamine at Joe's house. This is about, it goes beyond that. Like I've stated multiple times, I was very inebriated every time that I was at his house. I may have even been given ketamine without knowing it.
You've never told the police before in response to my question. Let me finish my question.
Look.
You'll get every opportunity, Mr. Spencer. I'm keeping my voice very calm. I'm going to give you every opportunity to talk as much as you'd like. But you've never before today in front of this jury made an allegation that somebody gave you ketamine without your knowledge. Isn't that true?
Can you please rephrase the question?
Yes. Until just now, you've never told the police or accused in a formal setting, in this case, Joe, of having given you ketamine without your knowledge, right?
Correct.
That's something new that you just told the jury now.
Well, maybe it was something that I didn't consider when I first stated that I only did it one time.
I'm sorry. I'm asking you, I'm moving on to another subject. You're here testifying in court. You understand that, correct?
Mm-hmm.
Yes?
Yes.
You've just made another allegation against Mr. Shield that he drugged you with ketamine without your knowledge. Isn't that true? That's what you just told the jury.
Yes, it is.
Never told that to any police officer formally, nor did you testify to that previously in this case.
I may have mentioned it before. I'm not sure. There were so many times that I talked to detectives.
You just told the jury a second ago that it didn't dawn on you to think about that. Now you're saying that you actually may have said something about that. Those are two different things, aren't they?
Do you want me to go back and explain myself?
No, I'm asking you a specific question, Mr. Spencer.
Yes.
So your testimony today includes a new allegation against Mr. Shield that you were somehow drugged without your knowledge.
I'm not saying that. I'm saying that it's a possibility. I'm not saying that that specifically happened. I'm saying it's a possibility, as in there's no way anybody's ever going to be able to know that. I don't even know that myself. I'm just saying possibly, and maybe I considered that when I just said that I took ketamine multiple times at his house. Maybe I considered that it's a possibility, but there's no way I'm ever going to know if it actually happened.
Wait a minute.
That's what I'm implying.
Under oath,
I'm not alleging him of anything.
Under oath, the prosecutor asked you on direct examination whether Mr. Shield, whether it had provided you with ketamine prior to, at the time she went to his house. She asked you that. It was a very simple question. Do you remember it? Do you remember the question and answer a few moments ago?
Yes.
And you said yes. And you said, almost every time I was there.
Yes.
And you're saying that when you told the jury that under oath, that you were thinking to yourself that maybe it was given to me without my knowledge? Is that your explanation for that testimony under oath?
Yes, it is.
Does that make any sense to you? That you would
Yes,
answer
it
a
does
question
make
directly
sense.
that he gave you drugs in the past, gave you ketamine in the past, but now when I'm questioning you, it's, well, maybe I was thinking of, maybe I was drugged and didn't know it. That's why I answered it that way. Is that really the explanation you want the jury to accept?
I don't know how else you would want me to explain this. I would appreciate if you could move on to the next question.
I'm sorry? You want me to move on to the next question?
Yes.
The questions I'm asking are, Mr. Spencer, pointing out from contradictions in your testimony. Do you understand that? So I appreciate you would like me to move on, but I'm sure you can appreciate that the judge will ultimately tell me when I have to move on. You understand that too, right?
Correct.
Okay. You want me to move on because it makes you uncomfortable to have to getting caught in what is untruthful testimony.
Well, there's a lot of these really small discrepancies, like how many times did you do this? How many times did blah, 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 that like, I didn't just like, this isn't like a test that I studied for. This isn't college. This isn't something that I think is like a huge deal. So when you guys throw all these questions at me and then throw it on the record, it's not something that's like constantly running through my mind every day, and I'm remembering all these little tiny little details and splitting hairs about it.
That's what I'm doing? You think I'm splitting hairs? I'm questioning you about the truthfulness of your testimony and contradictions, and you're telling the jury that that's splitting hairs. Is that what you're characterizing?
I'm giving my time trying to answer all of these questions to the best of my ability.
We'll get to the reasons why you're here later, okay? Do you understand? But I'm still going to put these questions to you. Is that okay with you, Mr. Spencer?
Yeah, ask another question.
Thank you.
Yeah.
You testified today that on February 15th that you drank alcohol. That's what your testimony was under oath just a few moments ago to the jury, right?
Correct.
You were asked this question at the preliminary examination, page 62, lines 18 to 19. did you drink alcohol that night? Your answer was no, I did not. Correct?
Correct.
Again, your testimony today is different than it was at the preliminary examination when you testified under oath there, right?
Correct.
You told the jury a few moments ago in response to Ms. Hand's questions that she asked you about nitrous oxide. Remember those?
Yes.
She asked you about whether or not you asked you about cocaine being provided to you at Joe's house. Do you remember that?
Yes.
You said that Joe had provided you with cocaine. You said that that was your testimony on direct examination. Do you remember that?
Yes.
That's not true, is it?
Pardon me?
Joe never gave you cocaine, and you didn't do cocaine at Joe's house. That's a lie, right?
Please, can you please rephrase the question?
The question was confusing to you?
No, can you just...
Yes. You testified today that Joe gave you cocaine and you used cocaine at Joe's house previously. That's what you testified to today. You've acknowledged that. I'm putting to you that that is not true. That is a lie. Correct?
That is not a lie. I did use cocaine at Joe's house.
Okay. On page 61, lines 15 through 17, at the preliminary examination where you testified closer in time, the question was put to you, did you partake of the nitrous oxide or the cocaine? Your answer was no, but I've heard and seen it at his house on occasions. Wasn't that your answer under oath then?
That may have been. I don't know. I
Is
haven't...
that both of those can't be true, Mr. Spencer.
Okay, so that was your answer at the preliminary exam, correct?
Yes.
Okay, what's the next question?
Both of those can't be true. What you testified to today to the jury and what you testified to under oath at the preliminary examination, right?
Yes.
So one of them is a lie.
I was lying about not using them.
You were
Because I felt
lying at the
guilty
preliminary
because-
examination.
I felt guilty because my dad was in the room.
At the preliminary examination, you were under, that's just so the jury understands that. You took an oath before you testified in the preliminary examination. Is that correct?
I didn't want my dad to hear that I was using cocaine.
You took an oath to testify to the truth at the preliminary examination in district court, right?
Correct.
You raised your right hand just as you did today.
Correct.
You looked, there was a judge there named Judge Nancy Karniak, right?
Correct.
You looked her right in the eye and answered the question, no. Isn't that true? And you're
Correct.
testifying now is that was a deliberate, intentional lie.
He said yes.
Isn't that perjury?
Well, he's,
Yes, it is.
he's-
Okay, I'll rephrase it. You recognize that when you're under oath, you face the penalty of perjury, don't you?
Yes.
You understand deliberately and intentionally lying under oath for any reason is perjury. Do you understand that?
Yes, I do.
So you concede that you committed perjury from your own perspective. By your own words, you committed perjury at the preliminary examination.
Yes.
This is where the courtroom enters its most uncomfortable territory, because now the issue isn't inconsistency, it's dishonesty. During cross-examination, Neil Rockin pressed Jacob Spencer on yet another contradiction, this time involving cocaine use. The discrepancy wasn't subtle, and unlike before, Spencer didn't try to explain it away. He admitted it. He acknowledged that during his preliminary examination, while under oath, he had lied. At that moment, the legal implications were no longer theoretical. Under Michigan law, Section 750.43 of the Michigan Compiled Laws, perjury is a felony. The statute is blunt. If a person willfully swears falsely about a material matter while under oath, the crime is complete. No complicated intent analysis, no gray area. By his own admission, Spencer checked every box. He was sworn in. He knew the statement was false, and he said it anyway. On paper, that is perjury. And that's exactly why Rockhind made the argument. Not because he expected Spencer to be arrested in the courtroom, but because he wanted the jury to confront a deeply unsettling reality. Here was the prosecution's witness admitting that he had lied under oath in a prior proceeding, and yet he sat protected. This is where use immunity stops looking like a procedural tool and starts looking like a moral problem. Because even though Spencer's conduct appeared to meet the statutory definition of perjury, he was almost certainly insulated from prosecution. The immunity agreement barred the state from using his own testimony as the basis for charging him with a crime. In other words, the truth came out, but accountability did not. That imbalance matters. The law allows it. The system depends on it. But juries don't have to like it. Rockhind didn't need the judge to declare Spencer a perjurer. He needed something far more powerful, permission to label him unreliable. And once a witness admits to lying under oath, credibility doesn't erode. It collapses. Every prior statement becomes suspect. Every answer feels transactional. Every word is filtered through self-preservation. This wasn't about catching Spencer in a mistake. It was about showing the jury that the prosecution's case relied on someone who had already proven he would lie when it suited him. Hughes' immunity kept Spencer safe from criminal consequences, but it couldn't protect him from the one judgment that actually mattered: the jury's. And that's the paradox at the heart of this moment. The system allows a witness to confess to perjury without punishment in service of a larger case. But in doing so, it risks poisoning the very testimony it needs to win. Rockin understood that risk, and he put it directly in front of the jury, not as an accusation, but as a fact the witness himself had confirmed. Sometimes the most damaging evidence isn't a document or a recording. It's a single sentence spoken under oath.
Police entered the house that night. You were in possession of drugs, right?
Yes, I was.
And tell us again what drugs you were in possession of.
Xanax.
Xanax. How many Xanax pills were you in possession of?
2.
And you did not have a prescription for those pills, isn't that true?
That's true.
You understood at the time you were possessing that it was a crime to possess them, isn't that right?
Yes, I did understand that.
You understood that it was a serious crime,
Yes.
and you understood that it was a felony.
Yes, I did understand that.
So you knew that when the police entered into the house that night that you were committing a felony.
Yes.
You knew that you were committing multiple felonies if you count the number of pills you possessed. Isn't that true?
Objection, Judge. It calls for a legal conclusion.
I would draw
That is true.
Yes.
I would draw it. It's fine. I would draw it. I'm asking questions very politely, Your Honor.
He is asking questions.
But you know that's not true.
Well, I don't know. I resent that because I'm not suggesting that I know that that's not true, and I don't like to suggest. You know me. I'm not suggesting
You
anything.
suggested to the jury that if you have 2...
I'm asking a question. You know what? Then I'm asking a question, and if I'm wrong about that, then I'm wrong about that, and I certainly will withdraw that.
All right,
So-
next question.
So I will withdraw that.
This exchange is a quiet reminder that even strong cross-examination has limits. During questioning, Neil Rockhind pushed Jacob Spencer on his possession of Xanax and framed it as something far more severe than the law actually allows. He asked whether Spencer understood that by possessing 2 Xanax pills, he had committed 2 separate felony offenses. The prosecution immediately objected, and this time the objection mattered. Judge Cheryl Matthews didn't just sustain it. She corrected the implication in real time, because Rockhind's question suggested something legally inaccurate, and courts don't allow juries to be missiled, even unintentionally. Under Michigan law, alprazolam, the active ingredient in Xanax, is classified as a Schedule IV controlled substance. Unlawful possession is governed by Section 43.7403 of the Michigan compiled laws. The statute is clear on one critical point. It criminalizes possession as an act, not dosage, not quantity, not pill count. If a person knowingly possesses a Schedule IV substance without a valid prescription, that conduct constitutes a felony. But whether the person has 1 pill or 10 pills at the same time, it is still a single offense of possession. 2 tablets do not equal 2 crimes. By framing the question as 2 felonies, Rockhind crossed from impeachment into misstatement of law. And that's where judicial intervention becomes necessary. This moment matters because it shows the balance courts try to maintain. Defense attorneys are allowed, even expected, to push witnesses hard. They can expose inconsistencies, challenge credibility, and test knowledge. But they cannot exaggerate criminal exposure in a way that distorts the law for the jury. Judge Matthews' ruling wasn't a favor to the witness. It wasn't protection. It was correction. And that distinction is important. Ironically, the sustained objection may have helped Rockhind in a different way. The jury still heard that Spencer possessed Xanax without a prescription, a felony in itself. What they didn't hear was an inflated version of that exposure that could later undermine the defense's credibility. Because once a jury realizes a lawyer has overstated the law, trust shifts. This exchange underscores a broader truth about trials. Credibility isn't just for witnesses. Attorneys are being evaluated too. Rockhin's earlier impeachment moments worked because they were precise, grounded, and legally sound. This one faltered because it stretched past what the statute allows, and the judge stepped in to draw the line. In the end, the ruling reinforced something fundamental about the justice system. Criminal liability is defined by law, not rhetoric. And no matter how intense a trial becomes, accuracy still matters, especially when a jury is deciding who to believe. Sometimes the most telling moments in a courtroom aren't dramatic confessions or emotional testimony. They're the quiet objections that remind everyone where persuasion must stop and the law begins.
When you agreed to testify at the preliminary examination, it was your belief that if you cooperated and testified that you weren't going to be charged in the case. Isn't that true?
Yes, that's true.
And despite whatever it is that you did, you believed at that time that you'll end up with no criminal prosecution and no criminal record. Isn't that true?
That's what I was told.
And who told you that?
That.
Ms. Hand, seated to my right and to your left. And despite whatever it is that you did, you'll end up with no criminal prosecution and no criminal record. That's what you're testifying to. That's what you just testified to.
Use immunity, I believe the term is.
And you just testified a moment ago that you were told that you'd end up with no criminal prosecution and no criminal record, right?
Well, no prosecution for the possession of prescription pills.
So that's more than use immunity. Use immunity means, doesn't it, as far as you know, that you just get to, your words can't be used against you. But you're telling us that you actually have an understanding that you're not going to be prosecuted at all for your felonies, right?
Correct.
Isn't that in part why you're in here saying the things you are about Joe, so that you avoid a felony prosecution and felony conviction yourself?
Correct.
You're a young person. You're 20 years old, you said? Yes?
Yes.
You want to have a career in the future, right?
Yes.
You have a lot to lose. Would you agree with that?
Yes.
And your participation or involvement in some kind of crime could interfere with that. Would you agree with that?
Yes.
You understood that based upon what you were being told, that if you talked about Joe, you'd be able to avoid being in trouble, right?
Yes.
1 year ago, well, so not 1 year ago, this was back in February 15th of 2017 is when this search of Joe's house took place, correct?
Correct.
And today is January 18th or 19th. 19th, Your Honor? 19th. Thank you. In that time, you have not been charged, have you?
No, I have not.
And there are things that you have, you did go down and talk to the police on March 1st of last year, correct?
Yeah, it was around that time.
You got a record deal the day before that, didn't you?
Pardon me?
Didn't you get a record deal? Did you get a...
That makes it sound like he's a singer.
No. Well, aren't you a performer, a DJ?
What does this have to do with...
Well, we'll let the jury sort that out.
Are you talking about this case?
Yes, I am. Yes,
I don't
February
think this
28th of 2017, the day before you went down to the police department to talk about Joe, didn't you get a record deal?
Oh, you do mean like singing?
I think a DJ.
Oh, I thought you meant, okay, all right.
Didn't you get a record deal? Didn't you get a contract by a company that signed you? Didn't you, something you were proud of?
I'm confused as to why you're asking me this and why you're asking me to disclose personal information.
He's trying to ask you if you have a lot to lose.
So on February 28th, before you went, you talked to the police, you got a record deal. You got a professional music contract. That was something you coveted, that you were proud of.
Yeah.
You understood that a criminal case and a criminal prosecution could interfere with that, didn't you?
Yes.
So the very next day, March 1st, that's when you went down and you talked to the police at the police station about Joe, right?
Yes.
Okay.
By the time the jury returned its verdict on January 24, 2018, the case had narrowed itself. After a multi-day trial, Joseph Sheely was convicted on 3 counts: possession of ketamine, maintaining a drug house, and possession of a firearm while maintaining that drug house. The remaining charges, including the most serious allegation, delivering ketamine to Jacob Spencer, did not survive jury scrutiny. That distinction matters, because this wasn't a clean sweep, it was a calibrated verdict. On March 5, 2018, Judge Cheryl Matthews sentenced Sheely to a total term of 3 to 4 years in prison. And when that sentence was complete, another consequence followed: deportation to Canada, his country of citizenship. The punishment extended beyond incarceration. The conviction permanently altered his life. But the most revealing part of this case isn't the sentence. It's how the jury arrived there. This trial became a live demonstration of how much weight a single witness can carry. and how fragile that weight becomes once credibility starts to fracture. Over the course of cross-examination, defense attorney Neil Rocken methodically dismantled Jacob Spencer's reliability. Not with theatrics, but with accumulation. First, conflicting testimony about how many times ketamine was allegedly provided. Then an admission of lying under oath about cocaine use. Then, evidence that Spencer initially intended to deceive police about possessing Xanax himself. None of these moments alone guaranteed acquittal. Together, they formed a pattern. And that pattern told the jury something uncomfortable. Spencer's story evolved only after he was assured he would not be charged. Use immunity didn't just protect him legally, it reshaped his incentives. Rocken's argument wasn't that Spencer lied about everything. It was more precise than that. He suggested Spencer told the version of events that best served his own survival, and the jury appears to have accepted that distinction. They rejected the delivery charges, the counts that depended most heavily on Spencer's testimony, while still convicting Shaley on offenses supported by physical evidence and independent proof. That split verdict speaks volumes. It suggests the jury didn't see the case in black and white. They didn't fully embrace the prosecution's narrative, nor did they dismiss the wrongdoing entirely. Instead, they separated what could be proven from what had to be believed. And belief, once shaken, doesn't recover easily. This outcome reflects the power and the risk of relying on incentivized witnesses. Use immunity can unlock testimony the state would never otherwise obtain, but it also invites skepticism because jurors instinctively understand self-interest. Rocken's cross-examination wasn't flawless. At times, it pushed too far. At others, it required judicial correction. But it succeeded where it mattered most. It introduced doubt exactly where the prosecution needed certainty. In the end, this case wasn't decided by a single question or a dramatic moment. It was decided by erosion, by the slow wearing down of confidence in one witness whose credibility could not withstand sustained pressure. And that's the lesson this trial leaves behind. In criminal court, evidence builds cases, but credibility decides them. And once a jury concludes that a witness is shaping truth to survive, the law doesn't demand rejection of everything they say, only enough doubt to draw a line. In this case, the jury drew it clearly. If there's another case, ruling, or courtroom exchange you'd like to break down next, let me know.